Hi friends, welcome to Labor Law classes. In Labor Law, we are going to discuss the Industrial Disputes Act of 1947. Today in this particular video, we shall learn about the definition of industry that comes under Section 2J of the Industrial Disputes Act of 1947. Things included and not included under the term industry. First of all, the definition of industry. After the Bangalore Water Supply and Sewerage Board Vs.A Rajappa case in 1978, the definition of industry modified. According to Section 2J of the Industrial Disputes Act of 1947, industry means any systematic activity carried on by cooperation between an employer and his workmen for the production, supply or distribution of goods or services to satisfy human want. So what is an industry? An industry is any systematic activity carried on by cooperation between an employer and his workmen. That is, there must be employer-employee relationship, and such an employment should be for the production, supply or distribution of goods or services in order to satisfy human want. Human needsinte satisfaction വേണ്ടിയിട്ട് employer-employee റിലേഷൻഷിപ്പോട് കൂടി തന്നെ പ്രവർത്തിക്കുന്ന ഏതൊരു സിസ്റ്റമാറ്റിക് ആക്ടിവിറ്റിയെയും നമുക്ക് ഇൻഡസ്ട്രി എന്ന് പറയാവുന്നതാണ്. ഈ എംപ്ലോയീസിനെ നിയമിച്ചിരിക്കുന്നത് ഏതെങ്കിലും ഗുഡ്സിൻ്റെയോ സർവീസസിൻ്റെയോ പ്രൊഡക്ഷനോ സപ്ലൈയോ ഡിസ്ട്രിബ്യൂഷനോ വേണ്ടിയായിരിക്കണം. അതുപോലെ തന്നെ എംപ്ലോയറിന് ഈ എംപ്ലോയീസിനെ നേരിട്ടോ അല്ലാതെയോ നിയമിക്കാവുന്നതാണ്. കോൺട്രാക്ടർ മുഖേനയോ ഏജൻസി മുഖേനയോ ഒക്കെ തന്നെ നിയമനങ്ങൾ നടത്താവുന്നതാണ്. എങ്ങനെയായാലും അവിടെ ഒരു എംപ്ലോയർ-എംപ്ലോയി റിലേഷൻഷിപ്പ് ഉണ്ടായിരിക്കണം. The workman may be employed by the employer directly or by or through any agency including a contractor, and the employment of these employees should be for the production, supply or distribution of goods or services to satisfy human wants. Such a venture may be public, private or joint sector, and it is immaterial whether any capital invested or not and the profit motive of the institution. An industry may be public, private or a joint sector institution. The capital invested or not is immaterial. It is not at all important whether any capital invested or not. Whether such an institution is making any gain or profit is not a criteria at all. Even if the organization is for philanthropic purposes, it is an industry. The capital invested is immaterial. The profit motive of the institution is immaterial. Then what is material? Or what is important in order to decide whether an organization is an industry or not? Yes, these four essentials are important. Any institution or organization which fulfills the above four essentials comes under the term industry. I hope Section 2J of the Industrial Disputes Act of 1947, that is the definition of the industry, is clear for everyone now. Now let's see what are the things included under the term industry. Educational, scientific, research or training institutions, hospitals and dispensaries, any charitable, social or philanthropic institutions, khadi or village industries, any domestic services, any professional activities, cooperative societies, clubs, all these comes under the term industry. The term industry does not include any agricultural operation which is carried on as the main activity. Strict sovereign functions are exempted from the term industry. But remember, the welfare activities or economic adventures undertaken by the government or statutory bodies are not exempted. They are industries. Number 3, solicitor's office. Solicitor means advocate. A solicitor's office is not an industry. Why? Because their services depend on the personal accomplishment of the solicitor. So it is not an industry. Number 4, a purely devotional or altruistic mission is not an industry.